would be unsafe to set down even the two who voted against the prohibition as having done so, in their understanding, any proper division of local from federal authority or anything in the Constitution forbade the federal government to control as to slavery in federal territory. The remaining 16 of the 39, so far as I have discovered, have left no record of their understanding upon the direct question of federal control of slavery in the federal territories. But there is much reason to believe that their understanding upon that question would not have appeared different from that of the 23 compeers who had it been manifested at all. For the purpose of adhering rigidly to the text, I have purposely omitted whatever understanding may have been manifested by any person, however distinguished, other than the 39 fathers who framed the original Constitution, and, for the same reason, I have also omitted whatever understanding may have been manifested by any of the 39, even on any other phase of the general question of slavery. If we should look into their acts and declarations on those other phrases, as the foreign slave trade, and the morality and policy of slavery generally, it would appear to us that on the direct question of federal control of slavery in federal territories, the 16, if they had acted at all, would probably have acted just as the 23 did. Among that 16 were several of the most noted anti-slavery men of those times. Dr. Franklin, Alexander Hamilton, and Gouverneur Morris, while there was not one now known to have been otherwise, unless it may be John Rutledge of South Carolina. The sum of the whole is that of our 39 fathers who framed the original Constitution, 21, a clear majority of the whole, certainly understood that no proper division of local from federal authority, nor any part of the Constitution, forbade the federal government to control slavery in the federal territories, while all the rest probably had the same understanding. Such, unquestionably, was the understanding of our fathers who framed the original Constitution, and the text affirms that they understood the question better than we. But so far as I have been considering the understanding of the question manifested by the framers of the original Constitution, in and by the original instrument, a mode was provided for amending it, and as I have already stated, the present frame of the government under which we live consists of that original and 12 amendatory articles framed and adopted since. Those who now insist that federal control of slavery in federal territories violates the Constitution point us to the provisions which they suppose it thus violates, and, as I understand, that all fix upon provision in these amendatory articles and not in the original instrument. The Supreme Court, in the Dred Scott case, plant themselves upon the Fifth Amendment, which provides that no person shall be deprived of life, liberty, or property without due process of the law, while Senator Douglas and his peculiar adherents plant themselves upon the 10th Amendment, providing that the powers not delegated to the United States by the Constitution are reserved to the states respectively or to the people. Now, it so happens that these amendments were framed by the first Congress which sat under the Constitution, the identical Congress which passed the act already mentioned enforcing the prohibition of slavery in the Northwestern Territory. Not only was it the same Congress, but they were the identical, same individual men, who at the same session, and at the same time within the session, had under consideration and in progress towards maturity these constitutional amendments and this act prohibiting slavery in all the territory the nation then owned. The constitutional amendments were introduced before and passed after the act enforcing the Ordinance of '87. So that during the whole pendency of the act to enforce the ordinance, the constitutional amendments were also pending. The 76 members of that Congress, including 16 of the framers of the original Constitution, as before stated, were preeminently our fathers who framed that part of the government under which we live, which is now claimed as forbidding the federal government to control slavery in the federal territories. Is it not a little presumptuous in any one at this day to affirm that these two things which that Congress deliberately framed and carried to maturity at the same time are absolutely inconsistent with each other? And does not such affirmation become impudently absurd when coupled with the other affirmation from the same mouth, that those who did the two things alleged to be inconsistent understood whether they really were inconsistent better than we, better than he who affirms that they are inconsistent? It is surely safe to assume that the 39 framers of the original Constitution and the 76 members of the Congress which framed the amendments thereto, taken together, do certainly include those who may be fairly called our fathers who framed the government under which we live. And so assuming, I defy any man to show that any one of them ever, in his whole life, declared that in his understanding any proper division of local from federal authority, or any part of the Constitution, forbade the federal government to control as to slavery in the federal territories. I go a step further. I defy anyone to show that any living man in the whole world ever did, prior to the beginning of the present century, and I might also say prior to the beginning of the last half of the present century, declare that, in his understanding, any proper division of local from federal authority, or any part of the Constitution forbade the federal government to control as to slavery in the federal territories. To those who now so declare, I give, not only our fathers who framed the government under which we live, but with them all other living men within the century in which it was framed, among whom to search, and they shall not be able to find the evidence of a single man agreeing with them. Now, and here, let me guard a little against being misunderstood. I did not mean to say we are bound to follow implicitly in whatever our fathers did. To do so would be to discard all the lights of current experiences, to reject all progress, all improvement. What I do say is, that if we would supplant the opinions and policy of our fathers in any case, we should do so upon evidence so conclusive, and arguments so clear, that even their great authority, fairly considered and weighed, cannot stand, and most surely not in a case whereof we ourselves declared they understood the question better than we. If any man at this day sincerely believes that a proper division of local from federal authority, or any part of the Constitution, forbids the federal government to control as to slavery in the federal territories, he is right to say so, and to enforce his position by all truthful evidence and fair argument which he can. But he has no right to mislead others, who have less access to history, and less leisure to study it, into the false belief that our fathers who framed the government under which we live were of the same opinion, thus substituting falsehood and deception for truthful evidence and fair argument. If any man at this day sincerely believes our fathers who framed the government under which we live used and applied principles in other cases which ought to have led them to understand that a proper division of local from federal authority, or some part of the Constitution, forbids the federal government to control as to slavery in the federal territories, he is right to say so. But he should, at the same time, brave the responsibility of declaring that, in his opinion, he understands their principles better than they did themselves, and especially should he not shirk that responsibility by asserting that they understood the question just as well and even better than we do now. But enough! Let us all who believe that our fathers who framed the government under which we live understood this question just as well and even better than we do now, speak as they spoke and act as they acted upon it. This is all Republican ask, all Republicans desire in relation to slavery. As those fathers marked it, so let it be again marked, as an evil not to be extended, but to be tolerated and protected only because and so far as its actual presence among us makes that toleration and protection a necessity. Let all the guarantees those fathers gave it be, not grudgingly, but fully and fairly maintained. For this, Republicans contend, and with this, so far as I know or believe, they will be content. And now, if they would listen, as I suppose they will not, I would address a few words to the Southern people. I would say to them, you consider yourselves a reasonable and a just people, and I consider that in the general qualities of reason and justice you are not inferior to any other people. Still, when you speak of us Republicans, you do so only to denounce us as reptiles, or, at the best, as no better than outlaws. You will grant a hearing to pirates or murderers, but nothing like it to black Republicans. In all your contentions with one another, each of you deems an unconditional condemnation of black republicanism as the first thing to be attended to. Indeed, such condemnation of us seems to be an indispensable prerequisite, license, so to speak, among you to be admitted or to speak at all. Now, can you, or not, be prevailed upon to pause and to consider whether this is quite just to us or even to yourselves? Bring forward your charges and specifications, and then be patient long enough to hear us deny or justify. You say we are sectional. We deny it. That makes an issue, and the burden of proof is upon you. You produce your proof, and what is it? Why, that our party has no existence in your section, gets no votes in your section. The fact is substantially true, but does it prove the issue? If it does, then in case we should, without change of principle, begin to get votes in your section, we should thereby cease to be sectional. You cannot escape this conclusion. And yet, are you willing to abide by it? If you are, you will probably soon find that we have ceased to be sectional, for we shall get votes in your section this very year. You will then begin to discover, as the truth plainly is, that your proof does not touch the issue. The fact that we get no votes in your section is a fact of your making and not of ours. And if there be fault in that fact, the fault is primarily yours, and remains until you show that we repel you by some wrong principle or practice. If we do repel you by any wrong principle or practice, the fault is ours. But this brings you to where you ought to have started, to a discussion of the right or wrong of our principle. If our principle, put in practice, would wrong your section for the benefit of ours, or for any other object, then our principle, and we with it, are sectional, and are justly opposed and denounced as such. Meet us, then, on the question of whether our principle, put into practice, would wrong your section, and so meet as if it were possible that something may be said on our side. Do you accept the challenge? No. Then you really believe that the principle which our fathers who framed the government under which we live thought so clearly right as to adopt it and endorse it again and again upon their official oaths is in fact so clearly wrong as to demand your condemnation without a moment's consideration. Some of you delight to flaunt in our faces the warning against sectional parties given by Washington in his farewell address. Less than 8 years before Washington gave that warning, he had, as President of the United States, approved and signed an act of Congress enforcing the prohibition of slavery in the Northwestern Territory, which act embodied the policy of the government upon which that subject up to and at the very moment he penned that warning. And about 1 year after he penned it, he wrote Lafayette that he considered that prohibition a wise measure, expressing in the same connection his hope that we should at some time have a confederacy of free states. Bearing this in mind, and seeing that sectionalism has since arisen upon this same subject, is that warning a weapon in your hands against us, or in our hands against you? Could Washington himself speak, would he cast the blame of that sectionalism upon us, who sustained his policy, or upon you, who repudiate it? We respect that warning of Washington, and we commend it to you, together with his example pointing to the right application of it. But you say you are conservative, eminently conservative, while we are revolutionary, destructive, and something of the sort. What is conservatism? Is it not an adherence to the old and tried against the new and untried? We stick to, contend for, the identical old policy on the point in controversy which was adopted by our fathers who framed the government under which we lived, while you with